strength and some credibility. Then you have the opportunity to then hear from the lawyers directly themselves. They can enhance that. They can simply say, I have no further comment on it. That probation officer has great experience, so sometimes when there are pro se litigants or attorneys who may not be focused on the right issue for their client, the probation officer will generally know what the judge is looking for to hear, and that may be something far more subtle than even the attorney can sense, no matter how many times they've been in front of the attorney. So it isn't just a 15-minute hearing in there. And then you have the opportunity to hear from attorneys for the counsel. You even have an opportunity to ask directly of the litigants themselves. You can see their passion. Again, as we spoke about discretion, you can see passion, you can see reaction, you can see body language, you can see it. And is it the best method? Probably not. But is it the most practical under the circumstances? Yes. How to address that? Hey, quick pretrial. Let's go. Get the discovery done. Let's get everything in order. Let's get everybody right back here. Let's see what the situation is. If a pretrial isn't necessarily the best step, well, how about a review date? Let's come back in a month, month and a half. Maybe the emotions have gotten aside. Maybe one party just got an attorney the day before. They haven't had a real opportunity to speak. Maybe they just need some time to really speak. And now that the attorneys are speaking, they come back before the court. They've either narrowed the issues, maybe even resolved it themselves. They've worked on it. But if not, if that's the kind of time frame you have, you better be listening carefully as a judge. You better be thoughtful. And you better ask the right questions that you need to make what you think is the right decision at that moment.
How long does a temporary order last?
Technically, when it's a question that I hear from my clients a lot, and I tell them temporary order lasts until the judge changes it, or you two agree something different.
Let's assume, with all due respect, you seem like a really nice person. Don't take this the wrong way. I'm talking about different people than you're talking about. I'm talking about a nice guy like you. And I'm talking about two nice people. They're angry, okay? And you think they have the best interest in mind. Let's call them two lawyers. There's no financial issues. There's no bed issues. I'm talking one family lives in Malden, the other one lives in West Roxbury. They both have beautiful homes. They both have a car in this home, bikes in each home. None of this like, oh, you talked about, well, maybe there's a drug issue. Or maybe I'm talking about two stellar parents who don't like each other and they're angry for whatever reason. That's where I'm getting into it. I'm not talking about that the mother's a drug addict or the father's an alcoholic and got help. I'm not talking about those people. So I want to understand where I'm coming from. A temporary order could last several months, couldn't it?
Absolutely.
You've got three wonderful kids out there. Would it bother you if when they were 4 or 5, you didn't see them for several months? That's what I'm talking about. I'm talking about how important is it to take your son to a baseball game? Is that important? How important is it to watch TV with your 3 kids at night? How important is it? Good night, kids. How important is that? How important is it in the morning to wake up and have breakfast, come home and have dinner? That's what I'm talking about. This hearing's going to go on for 2 hours. You've got 5 witnesses. You think that mother could have had 5 witnesses and the father could have had 5 witnesses? No way. The system isn't right. I'm talking about 2 people who are angry. What do we do in that situation? These kids are important to you, aren't they?
Absolutely.
That's who I'm talking about. And that's really troublesome to a lot of people out here. What are your thoughts on that? How do you get 15 minutes? I don't care about the financial issues. Somebody pays more than who cares about that? It's the kids I care about. You can't do it. I'm sorry to interrupt you. You can't do it when you got 10 minutes.
I share your passion when it comes to these children. I thank God every day that I'm in a happy marriage and have been, and I can kiss my kids goodnight every single night. I thank God. And being in this business, you appreciate that even more, frankly. The fact of the matter is that when you say you have two angry people, they don't need to like each other. They don't need to even respect each other as people. They need to understand that their children need two parents. And if they're both good people, and this husband may be the worst husband in the world, he may have been stepping out all over the place. That doesn't make him a bad father. And this mother may be so focused on work that she maybe doesn't do the laundry for the satisfaction of the husband, so he's angry. But that's not what's important. What's important is what kind of a mother, what kind of a father is this person, and why are they angry? What are their concerns about the children being here or being there? How do you address that? And again, yes, it may last several months, but it's up to the attorneys to have these people focus on the children, have the judge put a quick review date on it. If you have to make an order that you don't, you tell people. I often have judges say, listen, I'm not comfortable doing this in this kind of a session, but I need to make a decision because you two obviously can't. This is what I'm going to do. I want you back here in a month, and I want to know how it's going. And by the way, you better be talking, and you better be focusing on these children, because if I don't see it, these things change. And I am absolutely 100% confident that if temporary orders should be changed, and you as an attorney or a litigant argue for that change and give the judge sufficient credible evidence for warrant to change it, they will. Judges, for the most part, in my experience, I've never seen a lazy judge who just says, I'm entering the temporary order, that's what I saw on that day. Even though I didn't have any evidence other than maybe some affidavits, now I have evidence at a trial. I am absolutely open to a different arrangement.
With all due respect, I do disagree in real life talking to people, because what I think generally happens is, because the temporary order lasts so long, let's assume you have 3 kids and they're all with the father. You hate to say it, but in reality, they get brainwashed. Or 3 kids are with the mother, they get brainwashed. Oh, Daddy doesn't want to see you, so the order says you can only see you every other Wednesday and every other weekend. I mean, it's not quite as easy as you make it seem. You used the word to Councilor Devaney's question. You support joint legal custody. Those were your 3 words. What does that mean?
That means that every major decision affecting these children needs to be discussed between the 2 parents. It can be by email, it can be by phone, it can be in person, it can be through a meeting. But if 2 people are fit and they brought a child into this world, they should have equal opportunity to make those important decisions for their children. And parents differ on this sometimes. Ultimately, they may differ on the right school for this child. But there are ways of resolving that without demeaning the other parent, without diminishing that parent in the other child's eyes. Unless there's an emergency, no one parent should be making the decision for the other child, unless there are issues, serious issues of quality of fitness or domestic violence. But even then, there are many times where discussion is still required and ended.
I think just about every judge and I think everybody agrees on joint legal custody. I think the big issue is not joint legal custody. Oh yeah, what dentist you want to go to, who you want to be the pediatrician, and what school. Yeah, they may sound big, but everyone gets along. You know where I'm coming from. Joint physical custody, that's the name of the game. That is the name of the game. It's all about joint physical custody. And I'm not talking about the druggie, I'm not talking about the guy who works the late night shift, 4 to midnight. You got my point. I'm talking about 2 really good parents. You know, they work 9 to 5, both of them. They both cook, they both do the laundry. You know where I'm coming from. Do you have a feeling right off the bat, you know, I'm a supporter of joint physical custody? Or I've heard people here come before us who say, well, at the early age, maybe they'll up until 5, I think it's really the mother's when they're extreme, they should have more custody. Where do you come up on that issue?
So much depends, Counselor, on what's occurred during the marriage? Has one parent not participated in the childbearing? Has one parent not done this? Where are the parties live? I mean, for instance, you bring up an example of West Roxbury and Malden. Now, it's not practical if the children are going to school in West Roxbury to bring them in from Malden each and every day that they're with this other parent.
Why is it not practical?
Well, sometimes that means that the child is getting up a full hour earlier in their day, and they're not in a routine. Sometimes it works, sometimes it doesn't work. A lot depends, frankly, on the attitudes of the parent. I mean, I've seen cases where they've been in a two-family house and shared physical custody just wouldn't work because of the way. They've been in a two-family house and shared physical custody just didn't work. Yet I've seen people live in separate towns and make sure that shared physical custody works. And frankly, what I counsel my clients on, there's only one instance in the law right now that makes a distinction between shared physical custody and physical custody on one important issue that we both are well aware of. It's really more, what time are you spending with each other? You can call something custody, you can call something a parenting plan, and I wish that the law would talk about parenting plans and not physical custody. Decide where the children are going to go to school together, put that in your agreement, and then come up with a parenting plan. And that's a far more practical solution. That's a far easier concept for parents to accept. And if children understand, hey, and what they care about is, like you say, what time am I with Dad? When am I with Mom? What works for us? Work together.
I don't want to keep belaboring your point, but again, in my question, just so there's no confusion again, you keep throwing these. I'm talking about. I'm talking about the mother who's home when it's her week to be there when the kids got out of school. I'm talking about the father who's going to be there. I'm talking about after school, the mother is doing the homework. I'm talking about after school, the father's doing the homework. That's my point. You talk about, I know that's important, but I'm talking about that. You've got two super parents. That's my life. And they'll be only 5% of the people, 10%. I don't know. I'm not talking about, oh yeah, he wanted something. I know what it's about. Believe me, I know what it's about. And I didn't understand one thing you said that bothered me. What did you say about Malden? And you said impractical about Malden and West Roxbury.
That it may not be practical based on school choice of having.
Let's assume one of the kids live in Malden. I don't know, West Roxbury. I don't understand that.
Well, in other words, what if school starts in West Roxbury? They're going to go to school in West Roxbury. And let's say school starts at 7:30. Well, if school starts at 7:30 and they're coming from West Roxbury, they get up maybe 6:45, 7 o'clock. They have their breakfast, they brush their teeth, they get dressed, they go off to school, they're right down the street. If they're coming from Malden, they've got to get up, maybe 6 o'clock, maybe even earlier. They've got to get dressed, brush their teeth, they've got to have some breakfast, and get in the car, go through rush hour traffic, and get to school by 7:30. I'm not saying it doesn't work. I'm just saying that that's an aspect that the court has to look at and has to be considerate of, because what we're really trying to do is make sure these children succeed.
I agree. I'm going to tell you a story that I've never told before. If I didn't like that answer, I hope it helps you. I'm a divorced parent. When I got divorced, I had 2 little boys. And I had to fight. I'm lucky I had a really fair judge. My ex-wife lived in Hingham. I live in Jamaica Plain. West Roxbury, Malden. My little kids, it was Judge Ginsburg who gave me that shot. And I don't think you'd give someone like me that shot. And the reason I'm so passionate about this is because I got what 99.9% of the parents and the fathers and mothers don't get, and it's unfair. I should not be treated any differently. Let me finish. My kids live with me 50% of the time, not 48.5. 50. They came from Hingham, and they're wonderful kids now. One works for me. He graduated from Boston College. The other one's a senior at Trinity, another good school. They took the boat, imagine that, the boat from Hingham, got off at Rose Wharf, and they had to have those big, heavy backpacks and had those jaws to go to South Station to get the Orange Line. Oh, they went to, well, they had to get on the Orange Line. It's been a while. They're older now. And I picked them up at Forest Hills. Imagine what time they had to get up in the morning. And think about that going home. The school was about a mile from where I live. I heard what you said about Malden. Give someone a chance. It's the kids that matter. I am not convinced that you would give that father or mother, depending on the situation, the same chance that I had. I don't believe it. And I think that's wrong. My kids are wonderful kids. I had to fight for them. I'm not saying anything bad about their mother. Their mother is a phenomenal mother. But there are situations like that. They can do it. The mother never worked, which is totally fine. That's not. But it can work under situations like that. I came home from work at 3 o'clock to pick them up. I was there. But I had to fight for what I got. But there's other people out there. Give them a chance. Don't just say, oh, Malden, West Rockford. Guess what? It worked for me. It can work for other people. It's really something that I'm so passionate about. You would think that I got the shaft. I didn't. Every other week in the summer, I would take off. Yeah, granted, I have the financial means to do it. It's so important to me for these kids. And I really, and think of your kids when you make these decisions. And I know I get passionate about it. It means so much to me. It means so much to me. I hear so many stories. Yeah, you know the stories. Yeah, I see my kids every other weekend and on Wednesdays, 5 to 7. Yeah. That's really troubling to me. I didn't mean to get that passionate, but when you said West Rockford, Malden, that bothered me. I got another issue. There's one judge who has visitation or custody through the internet. You tell me your theory on that. In other words, they see their kids, and this was one where she allowed, I don't know if it was the mother or the father, to move out of state. That's troubling to me, because she wanted to be with her family. What was the visitation and custody? Over the internet. There's no one in this room that thinks you can have visitation and custody over the internet. Your thoughts on that?
I would second that thought completely. And I assume you're talking
The
about
removal.
Skype.
Yeah. I'm talking the removal statute.
Well, if I could address the Skyping part of it. Telephone calls and Skyping are not visitation. That enhances a relationship with a parent. That is certainly something that benefits children to be able to have daily contact. They come home from school, they got a great mark on their math test, they want to call Dad and tell Dad. Absolutely. But in lieu of visitation, no. That's absolutely not acceptable. I don't know the context of the case that you're speaking about.
It was a removal case that one went from Massachusetts. I don't know if it was the husband or wife, but it was all about one wanted to be, I don't know which one, wanted to be with their family, and I don't know where it was, Delaware, and that either one had a better job. So the judge said that parent could move. So my feeling, I'll tell you where I came, I don't think it's the best interest of the children to move with either the mother or the father because of financial reasons. I mean, your thoughts on that? It was a financial. Either he or she could, the mother or father couldn't got laid off, got a job in Delaware. Goodbye, kids. You never see those kids again, the other parent.
This is probably the most troubling issue for any probate family court judge, any practitioner, and litigants themselves in legitimate removal cases. And we're not talking about somebody who's just trying to get away from the mother or father. We're talking about, I met a guy, he lives over here, I want to move to that jurisdiction. And now, there were two very recent cases last week that came out of the appellate court. One even talked about moving from West Boylston, Massachusetts to Situate. They applied the removal standards.
Really?
And so they're keeping these same standards, and they talked about it. for in-state moves like that. The problem is that a probate family court judge is duty bound to uphold the law, not make law, not legislate. Until such time as the appellate court or the state legislature mandates different standards for removal. The best that a petitioner in our Commonwealth can do is argue vehemently for shared physical custody, because then there's a different standard than if one parent has sole physical custody. And as I said before, I had a wonderful, wonderful relationship with my children because I could tuck them in and kiss them every night tonight and read them a bedtime story. And I appreciate that. And to remove a child out of state, so that happens maybe once a month or even less, or on a school vacation or on a holiday, and then for an extended period in summer, is troubling to anybody who is a parent and who sits and does work in probate family court. But until that is changed, then as a judge in the probate family court, is duty bound to follow those same standards. Now, both of those cases, coincidentally, were remanded. So, as the appellate court, they may not be changing the standard, but what they've done is they've actually offered practical points that the judge wants to examine in these remand cases. What is the real impact emotionally on the mother of moving that child to Situate from West Wilson? You can't just talk about it, I'll be happier there. Give me something far more demonstrative that is going to support that kind of finding. So, even though they're not undoing the standard, they're narrowing it, they're defining it, and they're forcing the probate family court, and subsequently attorneys as well, get the evidence on these issues, and then weigh in fact.
Real quickly, thank you for that question. We'll get into it more. You're an attorney for the children.
I haven't.
You have been. Do you advocate that when you handle custody issues, and what situations would you use it and when would you not use it? Attorney for the children. In other words, you're the judge, and the 3 kids here, and when the judge appoints the attorney for the children, it's all.
The only time I've been appointed as an attorney for the child is when the children have been removed from the home sua sponte and placed into the custody of the Department of Children and Families, a form of social services. At that point in time, a child is mandated by law that an attorney must be appointed for the parents and for the children. And at that point in time, it's my responsibility to meet with the child, sit with the child, find out what's been going on, what are the risk concerns in mom's house, what are the risk concerns in dad's house, how do we approach this, and once this child is then placed back into the care or custody of one parent, that appointment ends and the case ends. But how you advocate as the attorney for the child is you can do one of two things. You can absolutely be an advocate for the child. If the child wants this, wants to go with dad, wants to go with mom, you advocate strongly for that. Or you can say, listen, the only reason they want to go with mom is because there are no rules at mom's house and dad has, strength.
Because I know I don't want to go too long, because my 15 minutes is, I'm kidding. Guardian ad litem, what situations?
That I have worked
on. Or would judge appoint with guardian ad litem? And you like the idea?
As somebody who has done a lot of GAL investigations, sometimes they're overused. Sometimes they're overused.
And when do you use them?
I really think as a practitioner, the advantage of a guardian ad litem is that we can go out, talk to the children, hear from them, bring it into court, testify what the children say, and it's not hearsay. It's an exception to the hearsay. So as a practitioner, I say to my client, we can have a guardian ad litem appointed who can go out and talk to all your witnesses, come into court, and report to the judge what these witnesses have said. And maybe the child's 2 or 3, so you're not going to get anything from the child. You hired me to do your case. Why do you want a guardian ad litem going out talking to these